2006 blast acquittals over seal for RDX. Minor details. What Maharashtra said in SC Plea. Maharashtra plea against HCS 2006 Mumbai train blasts case acquittals. The Maharashtra government on Tuesday moved the Supreme Court, challenging the Bombay High Court HC judgment acquitting all 12 accused in the 2006 Mumbai train blasts case. On July 11, 2006, 7 blasts within a span of 11 minutes in the first-class compartments of Western Railway WR local trains left 189 dead and several injured. The Mumbai court in September 2015 convicted 12 of the 13 arrested in the case. Mumbai train blasts case recap: 189 deaths in 11 minutes in 2006 to acquittal of 12 in 2025. Kamal Ansari now dead, Mohammed Faisal Ator Rahman Sheikh, Etesham Kutubuddin Siddiqui, Naveed Hussain Khan and Asif Khan were sentenced to death, while Tanveer Ahmed Mohammed Ibrahim Ansari, Mohammed Majid Mohammed Shafi, Sheikh Mohammed Ali Alam Sheikh, Mohammed Sajid Margub Ansari, Muzammil Ator Rahman Sheikh, Suhail Mahmood Sheikh and Zamir Ahmed Rehman Sheikh were sentenced to life imprisonment. The HC on Monday acquitted all 12 accused, saying the prosecution utterly failed to prove the case and it was hard to believe they committed the crime. Nanan, the Maharashtra government appealed against the HC judgment on grounds that the recovery of RDX from an accused was disbelieved on a hypertechnical ground that the seized explosives were not sealed with a lax seal, the PTI reported. Earlier in the day, Solicitor General Tushar Mehta, on behalf of the state government, mentioned the plea before an apex court bench headed by Chief Justice B.R. Gave and sought an urgent hearing. The court agreed to hear it on July 24, according to PTI. The state government, in its appeal, has raised several serious objections to the High Court's order of acquittal. The plea has asserted that due procedural safeguards under Section 232 of Maharashtra Control of Organized Crime Act were observed, including proper sanctioning by senior officers like prosecution witness PW number 185 Anamai Roy. It said the High Court overlooked the validity of these approvals despite no substantial contradiction in the prosecution's evidence. Watch Mumbai on Bombay High Court acquitting all 12 people in relation to 2006 Mumbai train bombings. Maharashtra CM Devendra Fadnavis says, "The verdict of the Bombay High Court is very shocking and we will challenge it in the Supreme Court." pic.twitter.com N9 Akjamval 9Y Ani July 21, 2025. Nanan, the plea mentioned the High Court's rejection of the recovery of 500 grams of RDX from one of the accused on the grounds that it lacked a lax seal. The plea has said that RDX, being highly inflammable, was not sealed for safety reasons and the recovery was duly sanctioned and documented. That the Hon'ble High Court has disbelieved the recovery of 500 GMS of RDX from accused number 1 on a hypertechnical ground that the RDX which was seized was not sealed with a lax seal. It will be pertinent to note that the same was not sealed with a lax seal because RDX is an inflammable substance. It is pertinent to note that the High Court records that the sanctioning authority for explosive substances has been examined by the prosecution. However, the Hon'ble High Court has not found any infirmities in the evidence of PW26, who is the sanctioning authority under the Explosive Substances Act for seizure of RDX from accused number 1. Therefore, the High Court has erred in disbelieving the recovery of RDX from accused number 1, the plea said, according to PTI. Nanan, and it has also disputed the High Court's dismissal of the confession of an accused for lacking minute details, such as the date of arrival of the Pakistani co-conspirators in India, the description of the 6 Pakistanis and information like whether they had trained in terrorist camps. The entire confessional statement has been disbelieved, which is an unacceptable conclusion, the plea has said, adding that omissions regarding the identities and origins of the Pakistani co-conspirators do not invalidate the overall confession. Also read innocent in jail in train blasts case. Why Lincoln lawyer ex-HC Judge Murali Dar said this. The appeal also challenges the High Court's disregard of the recovery of detonators and explosive granules from another accused, pointing out that these items cannot be easily procured or planted, and their evidentiary value should not have been dismissed over technicalities. The petition says the High Court failed to address the validity of the convictions under various provisions of the Unlawful Activities Prevention Act UAPA and relevant provisions of the Explosive Substances Act. It says the High Court ignored key findings and legal interpretations from previous landmark judgments. The plea addresses the defense's contention that the accused did not meet the definition of continuing unlawful activity under the MUCA due to earlier offenses being punishable by less than 3 years. Swipe left for next video. Citing Supreme Court precedents, the plea says the conspiracy and scale of the attack clearly fall under MUCA provisions. With PTI inputs, latest blogs.